better sentence section and we need to be about 15 minutes. Oh, there she is now. All right, are you Drew McGarry?
Yes, Your Honor.
All right, this is two cases before the court, both involving Mr. McGarry. Case number 21 CR 44, which is charged with breaking and entering and theft, and then case number 21 CR 106, which is charged with failure to appear. This hearing is being conducted by Zoom due to COVID-19 issues at the jail and in general. And Mr. Armstrong Jr. Klein both in agreement with that. This hearing being conducted by Zoom and waiving his personal appearance.
Yes, sir.
All right. And Mr. Gary, that is okay with you as well?
Yes, Your Honor.
All right. The court has received a plea of guilty for each of these two cases, Mr. Gary, and the first one is 21 CR 44. I'll hold that up to the camera and ask you if you recognize that as being agreed to plead guilty to count one.
Yes, Your Honor.
And then case number 21 CR 106, you recognize that as agreed to plead guilty in that case.
Yes, Your Honor.
All right. Now on page 3, on each of these forms, there are signature lines, and this is the 44 case. I'll hold up on page 3. About halfway, about a third of the way down, there's a sentence that reads, "I enter this plea voluntarily." Right below that, there's a signature line, and I'll hold that up to the camera. That's your signature right there next to my index finger.
Yes, Your Honor.
And in the 106 case, same sentence and a signature line. Is that your signature on that plea agreement?
Yes, Your Honor.
When did you sign these agreements, Mr. McGarry?
Today, Your Honor.
All right, and your attorney was there when you signed them?
Yes, Your Honor.
And did he go over each of them with you and explain them to you and answer any questions that you had?
Yes, Your Honor.
And did you understand that by signing these agreements, you're agreeing to plead guilty to the charges in both cases, so there won't be a trial? The next step will be a sentencing hearing?
Yes, Your Honor.
Your Honor.
Okay. Yes.
We actually signed them last Friday, and then the law has changed for sentencing after September 30th. So he signed new ones today with the new PRC language in them.
Gotcha. Okay. All right. Thank you. And by the way, Mr. Gary, I forgot to mention it, but since we're not having this hearing in the courtroom where you and your attorney are at the same table to speak, if you need to speak to him at any point, you just let me know, and I can put you and him into what's called a breakout room, so the two of you can discuss the matter without anyone else seeing or hearing you, and it won't be recorded.
Yes, Your Honor.
You understand? Okay.
Recording in progress.
Okay. Now, on case number 21 CR 44, Mr. McGarry, it indicates, well, open up the back up. Are you signing each of these agreements and entering into both of these plea agreements voluntarily?
Yes, Your Honor.
All right. Now, case number 21 CR 44 states you're going to plead guilty to the charge of breaking and entering under 2911.13a, fifth degree felony. And it further states you understand that the maximum prison term for that could be 12 months, minimum is 1 as opposed to 6. There's a fine available of up to $2,500. In case number 106, the charge is failure to appear under 2937.99, a fourth degree felony. The states you understand that the maximum penalty for that would be 18 months in prison. Minimum could be 6 if a prison term is imposed and a fine of $5,000. Do you understand that?
Yes, Your Honor.
Right now, if you are convicted of both of these charges and sentenced as opposed to prison, then the maximum prison term could be 30 months because it could be so important to be served consecutively, leaving one after another. You understand that?
Yes, Your Honor.
Based on any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently under community control, probation, parole, or post-release control for a felony from any jurisdiction?
No, Your Honor.
Right now, under the law, in the event that you are convicted of these offenses and sentenced to prison, at the completion of the prison term set by the court, it is possible that you could be put under what's called post-release control supervision by the parole authority for up to 2 years. And what that means is that they would make the decision, the judge doesn't make it, and if they decide that you should be under supervision, you'll be supervised for a period, again, of up to 2 years in the terms they set by a parole officer. And if during that period of time, parole authority determines that you have failed to comply, then they can return you to prison and make you serve an additional period of up to 9 months for one violation, but there is a cap or limit, a cap of whatever prison term is imposed for all violations. But if you commit a new felony while you're under post-release control supervision, then in addition to whatever sentence can be imposed in the new case, the judge could also sentence you for committing that violation while under post-release control. In these cases, to an additional period of 1 year, or whatever time is left on that 2 years of post-release control, whichever is greater. If that occurs, that would have to serve for a second legal sentence in the new case. You understand that?
Yes, Your Honor.
Now, in both of these cases, Mr. McGarry, it's not necessary under the law, it's not required under the law that you be sentenced to prison. I can impose what's called community control or probation instead of sentencing to prison, meaning you can supervise the term set by the court by a probation officer for a period of up to 5 years. And if during that period of time, the probation department felt you were not complying, they would file a written notice of that to the court. You would be given a copy of that notice and would be entitled to have a hearing and be represented by an attorney at that hearing. And if the outcome of the hearing was that you failed to comply, at that time, the court would sentence you to a prison term of between 6 and 12 months in the 44 case and between 6 and 18 months in the 106 case, and those would be ordered to be served consecutively. So that could be a total of 30 months. You understand that?
Yes, Your Honor.
Now, the charge in the 44 case alleges that on or about March 1, 2021 in this county, you did by force, stealth, or trespass in a building on State Route 506 in an unoccupied structure with purpose to commit therein a theft offense as defined in ORC section 2913.01 or a felony. And that is the charge of breaking and entering the 5th degree felony. The charge in the 106 case alleges that on or about May 19, 2021 in this county, you recklessly failed to appear as required in Highland County Complex case number 21 CR 044 after being released pursuant to ORC 2937.29 and released in connection with the charge of commission of felony, violation section 2937.299 of the revised code. So that's the charge of failure to appear in the 4th degree felony. Now, Mr. McGarry, do you understand what it is you've been charged with in each of those cases, what the state said you did, when, where, and how they alleged that you did it?
Yes, Your Honor.
Have you discussed the nature of these charges, the evidence in the cases, the possible legal issues in each case, the possible defenses that might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No, Your Honor.
Now, on page 2 of the both cases, there's a printing in bold near the bottom, and underline, and I'll read it in the 44 case first. It says you'll plead guilty to count 1. State will dismiss count 2. State defense will argue sentence. Defendant agrees to pay restitution to David Manning in the amount of $875. Then in the other case, it reads, defendant shall not plead guilty to the indictment. State defense will argue sentence. Has anyone promised you anything other than that case you plead guilty here today?
No, Your Honor.
No one's promised you that if you plead guilty, you'll be given a particular sentence.
No, Your Honor.
Now, you have certain constitutional rights, and I must understand before I can accept your plea of guilty. First, you have the right to have an attorney. Sergeant Trout is appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So, if you decide that you do not want to plead guilty, that you would rather defend against either or both of these cases, he'll continue to represent you in those cases, including a trial if that's what you want. You understand that?
Yes, Your Honor.
All right. Now, do you hold any professional license or certification from any state, agency, or board, or any kind of an occupation or profession?
No, Your Honor.
All right. Now, you have these constitutional rights, which understand the court can accept the plea of guilty from you, and they are as follows. First, you have the right to have a jury trial in each of these cases. There's 12 people would be selected from a group of citizens from this county that are selected for jury duty on your trial day. After they are selected, the evidence will be presented, they will be instructed on the law by the judge, and then the jury in each case will decide by unanimous verdict. It would have to be all 12 agreeing on the verdict in each case as to whether the state proved your guilt or proved beyond reasonable doubt. Now, if you didn't want to have a jury trial in either of both cases, you could waive in writing, which means to give up your right to have a jury trial in either or both cases, and in that case, you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence in that case. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Now, in each of these cases, you have the right to confront witnesses against you and cross-examine them through your attorney, which means the witnesses have to come into court and testify in front of you and your attorney and anyone else that might be present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have the right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, you request court issue court orders called a subpoena. That would force those witnesses to come to court to testify if you wanted them to, even though they didn't want to be there, which is the same way the state's witnesses would be required to come to court and testify against you in each case. Do you understand that?
Yes, Your Honor.
Right now, in each case, you have a right to, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in either case at any time by anyone. The prosecutor can't make you testify, the judge can't make you testify. You make that decision, and if you decide not to testify, the fact that you did not testify in the case could not be used against you in any way by any person at any time. And in fact, no one's even allowed to talk about it except in one situation. If you did not testify in either or both cases, then the judge will instruct the jury in that case that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, in each of these cases, Mr. McGarry, you are presumed innocent until proven guilty by the state of Ohio. Every essential element of each offense by proof beyond a reasonable doubt. What that means is the burden of proof is on you to try to prove you're not guilty, simply because you've been indicted. In fact, you don't have to present any evidence in your own defense in either trial, in either case. You can, but you're not required to. Whether you do or not, the fact that you did not testify cannot be used against you in any way at any time. As I said, the judge would instruct the jury then that they could not consider that for any purpose. Do you understand that?
Yes, Your Honor.
All right. Now, again, on the presumption of innocence, you do not have to present any evidence in your own defense. You can, but you're not required to. And if you do not, the jury will not consider that. But the state will still have the burden of proving that you're guilty by proof beyond a reasonable doubt on every element of each offense in each case. Do you understand that?
Yes, Your Honor.
Right now, originally you entered pleas of not guilty in these charges in both cases. That plea denied the allegations in each case, denied you committed any crime, exercised all of the rights I just described for you in each case. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. And if that occurs, then in each case you would waive and give up all the rights that I described for you this morning, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty in each case would waive and give up your right to a jury or court trial, would waive and give up the right to confront witnesses against you and cross-examine through your attorney, waive and give up your right to use the power of the court in each case to compel witnesses to come to court to testify for you, the same as the state. In each case, it would waive and give up your privilege against self-incrimination because you're the one saying you're guilty. That's what would be used to find you guilty. In each case, it would waive and give up your right to require the state to prove your guilt by proof beyond a reasonable doubt, because if you say you're guilty, the state doesn't have to prove your guilt. Plea of guilty subjection being sentenced immediately by the court, and finally, it waives gives up any right to file an appeal you think you could have had up to this point in the case. Now, if I were to sentence you to the maximum sentence in your case, you could appeal that. There are some other limited circumstances by which you could appeal. That appeal would have to be filed in 30 days if your sentencing entry being filed in that particular case. Do you understand that?
Yes, Your Honor.
And Mr. McGarry, are you a U.S. citizen?
Yes, Your Honor.
Now, do you have any questions about the charge in either case?
No, Your Honor.
Do you understand it?
Yes, Your
Do
Honor.
you understand the possible penalties?
Yes, Your Honor.
Do you have any questions about the plea agreement?
No, Your Honor.
Do you understand it?
Yes, Your Honor.
Any questions about the constitutional rights I've explained to you?
No, Your Honor.
Do you understand those?
Yes, Your Honor.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter a plea of guilty in either or both these cases here today?
No, Your Honor.
Do you understand?
Yes, Your Honor.
Is there anything you think you need to speak with Mr. Armitage about before we go any further?
No, Your Honor.
Dennis, is your decision to plead guilty to count 1 in the 21 CR 44 case and to the indictment in the 21 CR 106 case pursuant to terms of the written agreement that we've gone through in each case here this afternoon?
Yes, Your Honor.
And you're doing that voluntarily.
Yes, Your Honor.
All right, then as to the charge in the 21 CR 44 case alleges an on or about March 1, 2021, Highland County, Ohio, you did by forced stealth or deception, trespassing, building on State Route 506, Highland County, an unoccupied structure, purpose to commit therein theft, offense, defined in RC section 2913.01 or a felony in violation of 2911.13a of the Ohio Revised Code, charged with breaking and entering a 5th degree felony, carrying a possible prison term of between 6 and 12 months, fine of $2,500. How do you feel?
Guilty, Your Honor.
And as to case number 21 CR 106, which alleges an on or about May 19, 2021 in Highland County, Ohio, you did recklessly fail to appear as required in Highland County Complexities Court, case number 21 CR 0044, after having been released pursuant to ORC section 2937.29. The release is in connection with the charge of the commission of a felony, violation of section 2937.99 of the Ohio Revised Code, the charge of failure to appear. Fourth degree felony with possible penalty of 26 and 18 months imprisonment, fine of $5,000. How do you plead?
Guilty, Your Honor.
All right. The court finds on this day in each case the defendant provides of all of his constitutional rights, being knowing and intelligent and voluntary waiver of the same, pursuant to criminal rule 11. Pleas are accepted and ordered filed. Defendant is found guilty of count 1 and 21 CR 44. And of the charge in 21 CR 106, count 2 in CR 21 CR 44 is dismissed. Court orders that this matter be referred for a pre-sentence report under the same bond, which will include a assessment for substance use disorder treatment and or mental health. Sentencing will be October 21 at 1 p.m. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, thank you. All right, you may leave the room there, Ms. McGarry. We'll need Ms. Dingus in here now. All right, case number 21 CR 76. State of Ohio versus Geneva L. Dingus. Are you Geneva L. Dingus there at the jail?
Yes, sir.
All right. Matter is being heard by Zoom due to COVID issues at the jail and elsewhere. And the defendant's attorney is appearing by Zoom. That is Danielle Witt. Appearing on behalf of the state is Assistant Prosecutor Adam King. Dingus was indicted for aggravated possession of methamphetamine, 5th degree felony. She was arraigned, looks like on the 17th, that would have been Friday, by the magistrate in my absence, and bond was set at $2,500. Charged with 1 count of aggravated possession of methamphetamine and 5th degree felony. All right, Ms. Witt, well, this matter was set for a bond review hearing because pursuant to Rule 46, since counsel was not present at the arraignment, then the matter has to be reviewed within 2 business days. So, Ms. Witt, do you have anything you'd like to say?
Yes, Your Honor. I haven't had a chance to speak with Ms. Dingus, but just from a quick search, I do not see that she has a significant criminal history or has any failure to appear. So we just ask the court to consider releasing her on her own recognizance.
Mr. King, you have anything to say?
Thank you, Your Honor. This was initially a summons was issued in this case. A warrant had to be issued in June, but she was only recently picked up on that warrant. And during the arraignment, Magistrate Williams was asking her about her housing, where she would be residing if she were released from jail. And Ms. Dingus did not seem to have a stable housing history. So I believe that was the reason for the $2,500 bond at the time, Your Honor. Thank you.
All right, Ms. Dingus, on your financial disclosure form, it says that your address is 702 Poplar Street in West Union. Is that where you'll be living?
Yes, sir.
Who lives there?
Marlene, Martin, the friend of mine. I'm passed away Monday, and I have moved out of the house.
Have you ever been convicted of a felony?
Yes,
And have you served prison time?
no,
Okay, what was the felony conviction for?
and it was for arson in North County.
Arson?
Yeah,
Okay. When was that?
that's about 6 years ago.
You're not on probation, being controlled, post-release control or anything?
No,
All right, I'm gonna reduce your bond to an OR only, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony and convicted sentence on that regardless of absence in this case. You also are gonna be under the same range of conditions that, were ordered originally by the magistrate. You're to report probation department as soon as you get out of jail here this afternoon. That's at 117 East Main Street here in Hillsborough, uptown, just about half a block east of the courthouse. You know where that's located?
yes, sir.
All right, you get there by 4 o'clock. You're also within to report to them as they require, well, report to them once a week for 4 weeks, and after that as they require. And then all the other conditions that were set forth in the original arraignment entry still apply, including your house arrest at that residence, as well as if being referred for substance abuse, mental health issues, you'll be required to undergo that. If there's a recommendation for treatment, you'll enroll in and follow that during the period of this hearing or this case. You're also to provide your phone numbers for home cell employer and your drug test if they work. Do you have any questions?
No, sir.
All right, you'll be released here. We'll send this out to the court or to the jail momentarily.
Thank you.
All right. Are you Jacob Leonard there on the screen that says Christy S? Okay, you're on mute, so I'll need to unmute you there so we can hear you. There we go. All right. Okay, so you are Jacob Lee Leonard?
Yes, sir.
All right. Okay, this is case number 21 CR 98. Excuse me. Get that file on the back of the jail right away. She's re-released. Case number 21 CR 098, State of Ohio versus Jacob Lee Leonard. This matter is being heard pursuant to or under by Zoom. Mr. Leonard is appearing from here at the Massey House. Is that correct?
Yes, Your Honor.
Okay. His attorney is Danielle Whip, who's also present by Zoom. And then representing the state is Assistant Prosecutor King. Well, I see here this is for a plea for intervention, but I don't see my report. Was Marshall. There we go. It's there. Is there a report on Mr. Leonard? Yes. Did you see Mr. Fulton at the probation department, Mr. Leonard?
I think, yes.
After I put you in jail?
Oh, no.
They haven't contacted you to interview you for your pre-sentence report?
No.
Okay, but you are in treatment at FRS, I know that.
Yeah. The only person I had to talk to was Kim Davis, and she's the one that gave me the assessment.
Okay. Yeah. All right, here we go, we have it. All right, yeah, this report was actually prepared for your last hearing, and then you had not been to the probation department and had not been assessed, and so that's when I revoked it. So they just haven't updated this, but you are now enrolled, I know, at FRS. So the proposal is that there's been a motion filed for you to be granted intervention in lieu of conviction. And we had to continue the hearing because you did not have evidence that you were in an approved program, which you are now. And so I have these questions here that have been handed to me. They were actually signed back on July the 7th. This is intervention questions there. You see that with your case name. Sorry about that, trying to figure out how to do it. There you go. Can you read that okay?
Yeah.
All right. And then on page 2, there's a signature line down there. Is that your signature there? This one? Okay.
Yes, sir.
All right. And all the answers to these questions are correct as of that date?
Yes, sir.
All right. And there is now a recommended intervention plan, and he has been assessed and is in a separate plan. So the court will find that Mr. Leonard is eligible. And I have then presented a plea of guilty form, which indicates you're going to withdraw your not guilty plea and plead guilty to the charge. This form consists of a little over 2 pages, and there's an entry as well. At the top of page 3, there's a sentence that says, "I enter this plea voluntarily." And is that your signature on that line where my finger is pointed?
Yes, Your Honor.
All right. And then this is the first page. It shows that that form is your case name, number, and did you sign this document recently? Do you remember when you signed it?
I'm not exactly sure when I signed it, but I did sign it.
Okay, yeah, I think it had been signed prior to the last hearing, Ms. Witt?
Yeah, I believe it was back around July 21st.
All right. All right, well, Mr. Leonard, I'll go over this again with you, but when you signed this agreement, did Ms. Witt go over it with you and explain everything to you before you signed it?
Yes, sir.
And did you understand that it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And did you have enough time to fully consider this matter before making that decision?
Yes, sir.
And are you entering into this agreement to plead guilty voluntarily?
Yes.
All right, now, the agreement states on page 1 that you're going to withdraw your not guilty plea and plead guilty to the charge of aggravated possession of methamphetamine under section 2925.11 of the Ohio Revised Code, a fifth degree felony. And it further states that the maximum penalty for that, if convicted and sentenced to prison, could be 12 months. There's a minimum of 6 available, if there is one imposed. There's a fine available of up to $2,500. There's also a possible license suspension, 6 months and 5 years. You understand all of that?
Yes, sir.
All right? And you're not facing any felony charges in any of those jurisdictions, are you?
No.
And you're not on probation, community control, parole, or post-release control for a felony from any jurisdiction, are you?
No, sir.
Now, Mr. Leonard, I'm sure that this was reviewed by your attorney with you when you signed it, but I have to go over anyway to make sure you understand it on the record. So, normally, when someone pleads guilty to a charge, they're found guilty by the judge, and then they're sentenced. And that could be, like I said, it could be a prison term, could be a fine, could be a license suspension, could be community control, could be any combination. And after that happens, then that means that that person is a convicted felon. And there are certain disabilities under the law that apply, and other ramifications. Now, there's an exception to that procedure under what is called the intervention in lieu of conviction statute, which is what is being proposed to be applied to your case. What that is that if a person's drug addiction, substance addiction, whether it's drugs or alcohol or combination, or mental health issues, if any of those factors were a significant contributing factor to the crime, then under the law, if that person is in an accepted, approved, certified treatment program, which you are, then the court can accept a guilty plea from you, but instead of finding you guilty, puts you into what's called an intervention in lieu of conviction treatment plan and supervision. What that means is that you would be required to comply with your treatment plan, and that minimum requirement is that you be alcohol and drug free for at least 1 year. Even though alcohol doesn't appear to be the issue here, it's a substance that could lead to abuse and self-medication and issues with people in recovery. And so you're not permitted to use either of those, other than drugs for which you have a lawful prescription, provided you provide copies of that to the probation department immediately. Now, under the law, I can make that for up to 5 years. And you'd be supervised under some conditions at the probation department that I had previously adopted as planned in court. And if they feel that you have failed to comply, then they would have to file a written notice of that with the court. You would be entitled to have a hearing, and if the outcome of that hearing was that you failed to comply, at that time the court finds you guilty, and then you would be subject to being sentenced. But until that time, even though you pled guilty, the court doesn't find you guilty, because if you plead guilty, the proceedings are stayed, which means they're stopped for frozen. And even though there's a document in the court file that says you pled guilty, until there's a document that says you have been sentenced, you don't have a felony record or conviction. And so it tends for a period of up to 5 years. Now, I order 2 years, because 2 years to me seems to be a pretty good indication whether or not somebody's going to be able to be sober, stay sober, and obey the law. And so that's why I do it that way. Now, the advantage to you is this. If you successfully complete the treatment plan, say alcohol and drug free for 1 year, complete your plan, and then also apply with all the conditions of community control, then once I'm notified of that by the probation department, the case will be dismissed, even though you pled guilty. At that time then, and you won't have a felony record, even though you pled guilty. At that time I will set the matter for a hearing to seal the record, and 99% of the time those records are sealed, and then that means that no one is aware or can find it if they look at it in any of the public records, either the courthouse or any law enforcement records. So that's the advantage. The disadvantage is that if you fail to comply with the treatment plan or fail to comply with the supervisions that the court imposes upon people in this program, which are not as significant or as restrictive as persons who've been convicted, then if that is the finding of the court, you don't get to come back and start over. That time then you would be subject to being sentenced. So do you understand that?
Yes, sir.
Okay. I meant to say this at the beginning, but if you have any questions that you'd like to speak to your attorney about while we're doing this, please tell me, and I'll let you and her discuss this matter privately without anyone else being able to see or hear you. All right?
I'm good at this time.
All right. And also, I forgot to ask at the beginning, Ms. Whit, you and your client both waiving this presence here in courtroom and agreeing to this hearing being conducted by Zoom.
Yes, we are, Your Honor.
You're in agreement with that, Mr. Leonard?
Yes, sir.
All right, thank you. All right. Now, I have to give you the worst case scenario, so let's assume that you did comply. And there's a hearing, and you were found guilty, then you could be sentenced to prison. Now, at that time, I wouldn't have to send you to prison. I could put you under community control for another 5 years, up to 5 years. And that is when somebody has been convicted, you do have a felony conviction. Those conditions are more strict, and you would be required to comply with those. And again, probation department felt you were in compliance, they would file written notice out to the court. You'd be entitled to have a hearing, be represented by an attorney, and if the outcome of the hearing was you felt compliant, then at that time, the court would revoke your community control, and then sentence you to prison for between 6 and 12 months, and fine you $2,500. You understand that?
Yes, Your Honor.
Now, if you were sentenced to prison, then in the event that you served the entire prison term set by the court, under the law currently, upon completion of that prison term, the adult parole authority would have the rights, if they decided to do it, to put you under post-release control supervision for up to 3 years. What that means is that you'd be supervised by a probation officer, by a parole officer, under the term set by the APA, because the court has no involvement with that. If they decide you fail to comply, they can return you to prison for an additional period of up to half of your prison term for one or more violations. But if you committed a felony under post-release control supervision, then in addition to whatever sentence the judge in the new case would impose upon you, that judge could also sentence you to an additional period, in this case of 1 year or whatever time is left on the period of post-release control, whichever is greater. That occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
All right, now, the charge in the indictment alleges that on or about November 18, 2020, in this county, you knowingly obtained, possessed, used Schedule 2 controlled substance, methamphetamine. That's the charge for which is proposed to plead guilty. You understand what you are charged with in that case, in that indictment, what the state says you did, where, when, where, what, how they allege you did it.
Yes, Your Honor.
And you discussed the nature of the charge, the evidence in the case, the possible legal issues of the case, the possible defense you could try to raise in trial, the possible outcomes of the trial with your attorney.
Yes, sir.
Are you satisfied with your advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, Your Honor.
Now, have any threats been made to get you to plead guilty today?
No.
Other than the promise that if you plead guilty, you will be put into the intervention in lieu of conviction program, but not found guilty at this time, has anyone promised you anything to get you to plead guilty here today?
No, Your Honor.
All right, now, do you hold any license or certificate from any state agency or board for any kind of occupation or profession?
No.
Right, you have constitutional rights to understand the court and accept a plea of guilty from you, because again, this is your last chance to stand upon a plea of not guilty and defend against the case. So, first of all, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens from Highland County, summons for jury duty on your trial day. After they were selected, the evidence will be presented, they'd be instructed on the law, and then the jury will decide by unanimous verdict, meaning all 12 would have to agree as to whether or not the state proved your guilt by proved beyond reasonable doubt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you could waive, which means to give up in writing the right to have a jury trial. And in that case, you would have what's called a quarter bench trial, meaning the judge would be the one to hear the evidence, apply the law, and decide whether or not the state proved your guilt by proved beyond reasonable doubt. You understand that?
Yes, Your Honor.
In the Constitution, you have a right to confront witnesses against you, cross-examine through your attorney. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else that might be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
In the Constitution, you have the right to use the power of the court to compel or force witnesses to come to court and testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, to request court issues a court order, that's a subpoena that forces those people to come to court to be able to testify if they want to, even though they don't want to be here. It's the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right, under the Constitution, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify, I'll be used against you in any way, by any person, any time. No one's even allowed to comment about it, except in one situation. That is, if there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes, sir.
Of the Constitution, Mr. Leonard, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof is on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence of your own offense. You may, but you're not required to. Whether you do or not, the burden of proof will remain on the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, now, originally you pled not guilty. Not guilty plea denies the allegations in the indictment, denies you committed any crime, and that plea exercises or invokes all the rights I have just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're true, that you're the one who committed the crime that it alleges. In that plea, waives gives up all the rights I just described except the right to have an attorney. Waives the right to have an attorney no matter what your plea is. But with that exception, your plea of guilty, waive give up the right to have a jury or court trial. Waive give up the right to confront witnesses, to cross-examine through your attorney. Waive give up the right to use the power of the court, compel or force witnesses to come to court to testify for you, the same as the state. Waive give up the privilege against self-incrimination because if you say you're guilty, that's what you find you guilty. Waive give up your presumption of innocence because if you say you're guilty, the state's not required to prove guilty. It also subjects you to being sentenced immediately by the court. Finally, it waives gives up any right to file an appeal which you think you may have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under certain circumstances you may be able to file an appeal that would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Leonard?
Yes, sir.
All right, now do you have any questions about the intervention program or what's required?
I do not.
You understand it?
Yes, sir.
Have any questions about the charge and possible penalties for the offense?
I do not.
You understand them?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that here today?
I do not.
You understand?
Yes, sir.
And you have any questions about the plea agreement that indicates you plead guilty you can put into this program?
I do not.
You understand?
Yes, sir.
Anything you'd like to speak with Ms. Witt about before we go any further?
No, sir.
Then is it your decision? Well, do you have any questions about anything I explained?
No, I do not.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge in exchange for being put into the intervention program pursuant to the terms of this written plea agreement that we just went over?
Yes, sir.
Then as to the charge which alleges that on or about November 18, 2020, in Huntington County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11 of the Ohio Revised Code. The charge of aggravated possession of methamphetamine, fifth-degree felony, carrying possible penalty of between 6 and 12 months in prison, fine of up to $2,500, possible license suspension between 6 months and 5 years. How do you plead?
Guilty.
All right, the court finds then on this day in open court, defendants advised of all his constitutional rights may knowingly tell us voluntary waiver same pursuant to criminal 11. Please accept it in order to file. The court finds that the defendant's drug dependence and or mental health was a factor that led to the criminal activity for which he had been charged. Rehabilitation through treatment was substantially reduced the likelihood of any additional criminal activity. He has been accepted in an appropriate certified treatment program. He is otherwise eligible for community control, is not a repeat or dangerous offender, and is otherwise eligible for intervention in lieu of conviction under the requirements set forth in Section 2951.041 of the Ohio Revised Code. Therefore, it's ordered the judge to decree that the defendant's plea of guilty is accepted. However, there will be no finding of guilt made at this time, and the criminal proceedings are hereby stayed. Defendant shall be under community control, supervision under the control of the probation department under the term set previously by the court for this program for a period of 2 years. Included in that is his requirement that he successfully complete his intervention and treatment program and that he abstains from using drugs or alcohol for a period of 1 year. He's complied all the conditions for the program. He's also complete the plan and any other conditions of his community control that the probation department may require as authorized by the court. In the event the defendant, he also shall pay the court costs. In the event the defendant complies with all these conditions, the court will, on written notice of that from the probation department, dismiss the charge. And There will be no finding and the court will set, or ever finding of guilt, and the court will set the matter to sealed record. On the other hand, if the defendant fails to comply with any of the conditions or complete his treatment program or comply with it, then upon written notice of that from the probation department, the court will schedule a hearing, and the defendant will be represented by counsel, and the outcome of that hearing is that he is failed to comply. At that time, the court could impose a prison term of between 6 to 12 months, and fine him about $2,500 and suspend license for 6 months to 5 years. All right. Now that completes the case for now. A case that we put on stage, put on inactive status, and you will no longer under the terms of the pretrial supervision, house arrest, and those things. You're now under the new conditions. You'll need to contact probation department. Mr. Arjima, do you want him to call you, or are you going to make arrangements to see him, or what do you want?
Yeah, if he can call me as soon as he's done here, that'd be
Alright,
great.
as soon as you get done with this, call Mr. Arjima and set up an appointment, because he'll have to go over all those conditions and have you sign some paperwork, so.
Okay, can I get his number?
Yeah, I'll give you your number, Mr. Arjima.
937-393-0840, extension 112.
Alright,
Alright, thank you very much. Alright. Okay, are you Mr. Shoemaker there at the jail?
Yes, sir.
Okay. Okay, this is case number 20CR147. Ohio versus Thomas and Shoemaker. Mr. Shoemaker is heard by video.
Second case.
Center by Zoom.
2 cases, Your Honor.
And his attorney is Jake Wagner. There's also the 21CR166 also. Now, Mr. Shoemaker, since we're having this by Zoom rather than in person, you're not actually your attorney. Please speak with him. Just tell me how I'll put you in the breakout room for you and him to talk without anyone else being able to see or hear you, okay? I can't hear you, Mr. Shoemaker.
Okay.
All right, thank you. All right, now, Assistant Prosecutor King is attorney for the state, again, Jake Wagner for the defense. The defendant was originally indicted in 20CR147 for grand theft of motor vehicle, and then failed to return to the jail after he had been furloughed for medical treatment, and he was issued for his arrest. And it looks like the magistrate went ahead and did a scheduling order on that while I was gone. The matter is now set for trial November 15th. And then regarding 21CR166, he was arraigned, and Mr. Wagner went to represent him, and bond was set. In that case, was set no bond. Okay. And the matter was set today for a hearing. Bond should have been set in that case. I'm not sure why it wasn't done that way. But anyway, Mr. Wagner, you wish to address the issue of bond in the both cases?
Yes, sir, Your Honor. I guess to get to that matter, I was going to go out and see my client. I was informed that he had been incarcerated, but due to the COVID outbreak at the jail, got a little spooked, Your Honor. I'll admit that. So I went out there, then turned around and came back. But as far as the bond goes, I know we had a pending matter. He was furloughed for a medical condition. I'm not sure exactly what happened there. I am understanding there was some treatment, or he was transported up to Columbus. Your Honor, I'm not sure how the court or the prosecutor's office will lean on a bond at this point in time due to that furlough issue. We would just ask a reasonable bond, Your Honor, at this time.
Okay. All right. I see the reason it wasn't set, there was no bond set because of the key was on the 2047 case. So, The order, Mr. King, anything you'd like to say?
Nothing from the state, Your Honor.
All right, well, the court will set bond in the 147 case at $5,000 plus his own recognizance, $171 service fee deposit prior to release, and then the same conditions that applied in the original order. And in case number 21 CR 166, bond will be $5,000 plus OR and a deposit of $171. And also the same conditions that are normally said, that is that make the bond, you'll report probation immediately, report within 1 week, 4 weeks, and after that as they determine. To go random drug testing they may order, provide phone numbers from home some employer. If recommended, submit the drug testing when as directed, recommended by probation, you'll be evaluated for substance abuse and mental health issues, and treatments indicated you will follow that during this action. And you'll be under house arrest at your residence, which I believe is unless you're a PO box something, but you have to have a physical address and give that to. And
I got a physical address.
all right, what is that?
9256 State Route 772, Pikesville, 4561.
All right, so you have to be there all the time, unless you're working, going to and from work, medical appointments, court proceedings, and this or any other case, or appoint to your attorney, or probation officer in this or any other case. Other than that, you have to be there all the time. Self-compliant, then the court can revoke that bond and be held till further court. All right. I'll just tell you now, Mr. Shoemaker, don't ask for another furlough. Get sick again, sheriff's gonna, as far as I'm concerned, unless you die, they don't have to take you to the hospital, but they have their own standards they have to decide to comply with, so that'd be up to them, but you won't get any more breaks in this court. All right, thank you. All right, are you on Mr. Boyd as well, Mr. Wagner?
Yes, Dalton Boyd, yes, sir.
Okay. All right, are you Dalton James Boyd?
Yes, sir.
Okay, this is case number 21 CR 031. State of Ohio versus Dalton James Boyd. Mr. Boyd is appearing on video at the Justice Center by Zoom, actually, due to COVID-19 issues. His attorney is present by Zoom from his office, Jacob Wagner, and representing the state's Assistant Prosecutor King. The defendant has been charged with failure to comply with order single police officer and aggravated possession of methamphetamine. I believe this is a first pre-trial, and final pre-trial set for the 6th of October, and then a trial is set for November 8th. I see that there was a request for discovery, which has been provided by the state, and I think it might have been filled particulars as well. Yes, that's been filed. Have you filed your discovery yet?
I have not, sir. I did go out already, though, Your Honor, to speak with Mr. Boyd. The state's supplied me a plea offer. We've gone over it. I anticipate that it's already signed, being entered into. We'll use the final pre-trial or date in between then, Your Honor, to get this taken care of.
Okay. You don't anticipate any pre-trial motions then?
I don't, sir.
All right. Well, anytime you're ready, if there's an agreement reached, let the court know we'll get a time.
Yes, sir.
Thank you.
Thank you, Your Honor. That's good, Mr. Boyd.
All right.
Have the arraignment.
All right, Mr. We're going to ring it here.
Hertzler.
Our next hearing is Ms. Hackner, 145. No, 2. Wait a minute. We're at 2 o'clock.
2 o'clock, yeah. We have Hertzler at the
Hertzler's
jail.
the last day. Okay, sorry. Bring in.
Your Honor.
Mr. Hertzler.
Your Honor, is it?
Are you ready for a Hertzler or would you like a picture?
Hertzler.
We're not,
Okay, give us just a minute, because he's been around COVID, so we just gotta.
Who do you have out there?
I have Fisher, he had a notification this morning by Sandy Kelly.
yeah, that's the one we were waiting till tomorrow to do.
Oh, we're gonna do that one tomorrow.
Okay,
But
we just have him here just in case.
Is he out there in the hallway?
Fisher is, yes, but I can
Come on
send
in
him back.
and do it, we'll get the file. Go ahead and do it, we'll get this person.
Okay, you wanna go get a Hertzler for me, make sure he has a mask, gloves, everything. Sorry, Your Honor, we were trying to be.
No problem. So I'm gonna get the file here, we'll do this.
I need a case number on it. I haven't had it in the system yet.
You got it.
No. It's just a case number.
18076.
18 CR 176.
076. Joshua S. Fisher.
076.
18 CR 076.
076. Okay. And this is a notification.
All right, you're Joshua S. Fisher?
Yes, sir.
Not ready yet, Your Honor.
Oh, I'm sorry.
On the record.
All right, case number 18 CR 076, State of Ohio versus Joshua S. Fisher. You are Joshua S. Fisher, appearing by video from the jail.
Yes, sir.
All right, you're waiving your presence in court, agreeing to have this hearing conducted by video.
Yes, sir.
All right, the defendant was convicted of burglary, a second-degree felony, and was sentenced to a term of 3 years of incarceration back on 6/15/2018. Then on June 4th of 2020, he was granted judicial release and to the STAR program. Now, there's been a notification filed by the probation department that you have failed to comply with those conditions. That was filed on September the 20th, and it alleges that, which is today, it alleges that you violated several rules, including Rule 2, that you failed to report since May 5, 2021. Rule 3, that on August 2, 2021, a letter sent to you at your last known address came back and returned to sender. Rule 18, the victim witness records indicate restitution amount owed is $2,967.92. No payments indicated since April of 2021. Rule 19, that you failed to enroll and complete a substance abuse treatment as directed by probation department. And that's signed by Officer Kelly. And did you sign a copy of this or receive a copy today, Mr. Fisher?
Yes, sir.
All right. Now, under the law, Mr. Fisher, in the event that the court finds that you have failed to comply with these conditions, I could do one of three things. I could continue committing control under the same conditions I originally ordered when I granted you judicial release, or I could continue with additional conditions I think are appropriate, or the third and most serious for you is that I could revoke your control and your judicial release, return you to prison to serve the rest of your 3-year sentence, although you would get credit for any jail time you've had, as well as any time that you've been at the start. Now, you are entitled to have a hearing in this matter in which the state is required to present evidence to the prosecutor's office that you have committed these violations. You have a right to have your attorney cross-examine those witnesses or do it yourself if you're not represented by counsel. Try to bring out evidence that helps your side of the case. You're entitled to have a reasonable period of time to prepare for that hearing. Today is not the purpose of that. Today's purpose is simply to notify what the allegations are. You have a right to subpoena witnesses to come to court to testify for you, just like the state. And you can present evidence in your own defense, although you're not required to, but if you don't, it won't be held against you. Now, you're also entitled to have an attorney to represent you in this matter, to advise you on options you might have, strategies, tactics, arguments to advocate on your behalf, to help you present evidence in court, and to question witnesses for you, to cross-examine the state's witnesses, try to bring out evidence in your case, and then also to present your testimony and any other witnesses that you may have, if you choose to do so. Again, you don't have to. Now, you understand those rights, Mr. Fisher?
Yes, sir.
And do you wish to have an attorney to represent you in this matter?
I do, cause there's
Okay, well then that's fine. You want an attorney, that's all I need to know. Then, did you fill out an attorney, a financial disclosure form? Did you fill out a form requesting an attorney, your financial information?
No, did not.
not this time, no, sir.
You'll have to fill one out there at jail, and then assuming that, you qualify, which I'm sure you do, court will, appoint, counsel for you, and I'll go ahead and do that now. Let's see, who was your original attorney? William Armstrong. So the court will appoint Mr. Armstrong to represent you. We'll set this matter for an evidentiary hearing. Did we set another motion date for October 7th? I know we had to. No. Or do we have anything more?
Yeah, you're out though.
In the afternoon.
I do have some for you, so we did that, but.
Oh, wait,
You said you're out.
that's fine.
10?
Oh,
Oh, no, you told me to mark ready to move everything today.
all right, well, then what about the 6 times the oh, okay.
Can't have our part of the informed.
All right, then we'll do it, yeah.
That's what I'm asking.
All right, October the 6th at 3 p.m. And you'll be held without bond. All right, do you have any questions?
No, sir.
All right, thank you.
Thank you, sir.
All right. That's the last one, Mr. Dale?
Hertzler arraignment,
Oh, right.
the arraignment.
Yeah, all right.
The name on your.
Okay.
I gave you that reading report on him, didn't I? Okay.
All right, are you Christopher R. Hirschler?
Yes, sir.
All right, this is case number 21 CR 165, State of Ohio versus Christopher R. Hirschler. Mr. Hirschler, you were indicted by the grand jury of this county back on September 14th on looks like about 9 charges, and it alleges count 1 that on between the period of October 30 of 2020 and January 1, 2021 in this county, Wesley Howard and you and other unindicted co-conspirators recklessly, while being employed by or associated with, directly or indirectly, conduct and participate in various enterprise through a pattern of conducting corrupt activity. At least one of the incidents of corrupt activity is a felony in first, second, or third degree. So that's a first degree felony, which carries a possible prison term of between 3 and 11 years set by the judge, with a maximum of up to half of whatever term the judge set as a maximum. Count 2 alleges that on or about November 6, 2020, in this county, Mr. Howard used, only sold or offered to sell methamphetamine at Schedule 2 controlled substance amount equal to or exceeding bulk amount of less than 5 times bulk amount considered juvenile. Count 3 alleges that on or about the same date, you can only obtain, possess, or use a Schedule 2 controlled substance with methamphetamine in that amount on the same day. Both of those are, well, count 2 is a second degree felony, which carries a possible prison term between 2 and 8 years at the minimum and a maximum of half of whatever sentence the judge imposed in addition. And a fine of $15,000. Count 1 is a fine, I believe, of $20,000. Count 3 is a third degree felony, which has possible penalties between 9 and 36 months in prison, fine of $10,000. Count 4 alleges the same offense as count 2, except that it occurred on November 9th. And count 5 alleges the same as count 3, except on November 9th. Again, the same penalties apply to that. And count 6 and 7, same thing, repeat sale or offer to sell as well as possession on November 12th. Second and third degree felonies as well. Count 8 alleges, 9 alleges the same thing happened as alleged in counts 2 and 3 on November 16th. All right, now, you are entitled to have an attorney represent you in this matter, Mr. Hirschler. If you can't afford to hire one, court will appoint one for you. Says you're hiring a lawyer, so who is your lawyer going to be?
I haven't decided yet. This happened to me, so I don't know. I have no resources of being able to contact the lawyer at this time.
Do you have the funds to hire an attorney?
I mean, I have a little bit, maybe nowhere a lot, $1,000 maybe.
You have $1,000?
Maybe. My wife did it to make my wife.
Well, how are you going to hire an attorney if all you got is $1,000? But I'll tell you right now, no attorney that you would want to represent you would take this case for $1,000.
Yeah.
It's
I mean, the allegations against me are false. So
I can't understand you. You can take it back down when you're talking.
I'm saying that the allegations against me are false. So I'm just.
Well, yeah, that's fine. I mean, you're presumed innocent. I'm not saying you're guilty. I'm just telling you that for $1,000, you're not going to get.
I understand that.
Do you have any other way to hire an attorney through friends or family or somebody else to be able to help you?
If I could talk to my parents, maybe. Or I could get family members to help me. I could have, people that will help me. I have people that will help me, like family members and stuff. I just haven't been able to talk to them because I've been here. So all this is just new to me. This just happened this morning. So.
All right. Well, I'm going to go ahead and enter a not guilty plea on your behalf in the absence of counsel. And we'll set a review hearing on this matter for Wednesday, which is September 22nd at 8:30 in the morning. Then your first pretrial will be set for October 6th at 1 o'clock. That'll be by Zoom, and the 22nd will be by video. The final pretrial will be November 3 at 1 o'clock, also by Zoom. And we'll set the trial date for December 13 at 8 a.m. You were just arrested this morning? Is that correct? All right. All right. Bond will be set in the amount of $50,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case. You'll also be required to pay a deposit of $171 for certain statutory required fees. If you make bond, you'll be under pretrial supervision of the probation department, 117 East Main Street, which means you'll have to report to them immediately upon your release, and then once a week for 4 weeks, and after that, as they determine. You're required to undergo random drug testing in May order, provide phone numbers for home, self-employer. If have no contact with co-defendant, in this case, Mr. Howard. If recommended by probation, you'll be evaluated for substance abuse and mental health issues, and treatments indicated, enroll in and follow that during the period of this case pending. Be under house arrest at your residence, which means you have to be there at all times unless you're working, going to and from work. Medical appointments, court proceedings, in this or any other case, appointment with an attorney, probation officer, in this or any other case, or attending kind of school, job training, educational programming, or church services, other than that, you have to be there at all times. What is your address, Mr. Purser, where you would be living if you're released?
705 North High Street.
705 what?
North High Street.
I'm sorry?
North High Street.
North High Street? Is that in Hillsborough?
Yes, sir.
Okay. All right.
Now, I was trying to talk this morning about how I may have proof that I haven't been tested. And I'm just like running with chest pains and like stomach abdominal pains. Like, I can hardly breathe and stuff. So I'm wondering if I could get tested for it.
Well, Sheriff will take good care of it. They're used to that kind of thing. All right. Thank you.
Are you appointing counsel for the bond review hearing?
No. All right, now that, is everybody in the jail?
That is everyone at the jail, Your Honor.
All right, so they can sign off. All right, now, who are you there on iPhone?
Madeline Arnett.
Madeline Arnett, all right. Okay, and see, Mr. Wagner, you're her counsel, right?
Yes, sir, Your Honor.
All right, case number 21 CR 36, State of Ohio versus Madeline Grace Arnett. Ms. Arnett is appearing by Zoom on the screen and has iPhone as the identifier down in the right-hand corner. Her attorney is Jake Wagner. He's appearing by Zoom in his office, and the prosecutor, assistant prosecutor at King is appearing by Zoom as well. Hearing is being conducted by Zoom due to COVID-19 protocols that we put in place because of the increased number of cases in this county. This defendant was charged with malicious assault and a forfeiture. And I believe we have a trial date, was originally, I believe, set for next day. And that matter was continued, I believe. And all right, and Ms. Hacker was originally on the case, that's right, I believe. But I don't have an entry here where we continue that for some reason. Maybe I do, and it's out of order. Let me see here. Well, wait a minute. I have Ms. Hacker down as Arnett's attorney.
If I may, sir?
Yeah.
I inherited this one, Your Honor. I believe I was not at the hearing, but there was a status hearing. Ms. Hatner withdrew. This is my first pre-trial with Ms. Arnett. I'm looking through her file. I don't see a scheduled trial date, Your Honor.
The trial is set for October 14th.
Okay. Is there a continuance entry that was filed?
There was an entry on September 2nd, granting Hatner's legal withdrawal, appointing Mr. Wagner, and setting a pre-trial and trial date. That was September 2nd.
I'm glad you have that, because I don't.
Oh,
no, wait a minute. I found it. Here it is. All right. Yeah, so, final pre-trial was actually set on Wednesday. We moved it to Monday. Mr. Wagner was good enough to do that because we actually made cases set Wednesday and then trial set on the 14th. All right. So, did you get all the file and everything from Ms. Hacker?
I have, sir. If I may, Your Honor.
Yes, go ahead.
Ms. Arnett and I have met once. We were scheduled to meet again today. She's been in very good communication with me. She indicated she was not feeling well. I said, look, let's just do this hearing by Zoom today. She was going to come in and actually meet and Zoom to the court. I don't know. I know the case is getting older, Your Honor, and I respect that. If the court would give me a week or a couple more weeks on the jury trial, don't set me for another pre-trial. The court would be so inclined. If I get something worked out, I'll report to Ms. Oyer. If not, we'll be ready for trial, Your Honor. Discovery's complete. We've met. Again, I say on my client's behalf, Madeline's been in very good contact with me.
All right. Ms. Arnett, do you have any problem with the court continuing the case for a couple of 2 to 4 weeks? I'll have to look at our calendar here, but you have any problems since he's just gotten in the case? Make sure you have enough time to communicate with him and get prepared for the trial.
I am compliant with whatever works, Your Honor.
I mean, you're okay with this matter being continued then? All right. Because given the under the law, you have a speedy trial right to have a trial in 270 days. We're still well within that. But any time we continue a case at the request of the defendant, it extends that time. So you understand that, and you're in agreement?
Yeah.
All right. Well, the court then will grant the oral request for continuance.
Thank you, sir.
So the jury trial set for the 14th will be continued to November 8th. At 8 a.m. And the speedy trial time will be told pursuant to 2945.72H on the motion of the defendant and waiver of the defendant. All right, anything further to counsel then?
No, Your Honor.
No, sir.
All right, thank you.
Thank you, ma'am.
Thank you.
All right, now. Dustin Swords.
He's in my office, sir. Hey, Dustin, come on back, bud. He didn't have the Zoom capability, or I had him come to my office.
All right, thank you.
Take your hat off, bud. Consider this a court of law. Right here.
All right, case number 21 CR 86, State of Ohio versus Dustin L. Swords. And that's you, Mr. Swords, sitting behind Mr. Wagner there on the screen?
Yes, sir.
All right. And his attorney is also present. This hearing is being conducted by Zoom due to COVID-19 safety protocols in place. The defendant's charged, also represented by the state as attorney, assistant prosecuting attorney advocate. Defendant's charged with aggravated trafficking and aggravated possession of methamphetamine, both third-degree felonies. The matter is set. Let's see, Mr. Kirk was originally the defendant's attorney, and had to withdraw. Mr. Wagner was appointed, and it's a final pre-trial. We have a jury trial set for October 12th. Mr. Wagner, did you get the file and all the discovery or everything from Mr. Kirk?
I did, sir.
Okay. And there are no pre-trial motions?
No, if I may, Your Honor.
Go ahead.
Much like Miss Arnett, this is my kind of first pre-trial with the court, and I met with Dustin again. He's been very compliant with me. He's been in phone contact. Actually came in this morning. We went through discovery today. He got to view the video. He hadn't got to do that in the past. We went through the video today, broke that down. I don't know if the court would be inclined to kind of grant me the same continuance as Miss Arnett's instead of on the same day. Either I'm going to try these cases or they'll be worked out before then, Your Honor. But again, this is the first time. I'm not blaming Mr. Kirk for anything, but it's the first time he has seen the video, Your Honor.
Okay, well, this case started out in May, let's see, and there was a continuance. To, I believe, August. Okay, well, actually, you filed for continuance with the trial date on August 26th, that was on August 20th. And let's see, I sent that to the 12th of October. So I'm not going to grant a continuance on this one, Mr. Wagner.
Okay.
If you need another trial date, or if you have anything else, let me know. But otherwise, we'll assume this tonight is going to be on the docket for the 12th.
Yes, sir.
All right. Anything else, then, counsel?
There you go.
All right.
One question, Your Honor.
Sure.
I know this court's strict rules as far as being within the 14-day window.
That'd be the 28th of September, which would be next Tuesday.
I just know the prosecutor's office is short-staffed, arguably, here in the next 4 or 5 days. If I get pinched within that, would the court grant me leave if I keep it?
Yeah, if you have an agreement, yeah, we can let it go a day or two past that.
Thank you, sir.
Yeah, okay. All right.
Thank you, Your Honor.
All right. Tasha Rose, is she there, or you know where she's at?
He's likewise in my office, Your Honor.
All right.
Your Honor.
Natasha?
All right, this is case number 21 CR 102, State of Ohio versus Natasha J. Rhodes. And are you Natasha J. Rhodes sitting there at right over Mr. Wagner's shoulder in his office?
Yes, Your Honor.
All right, this Rhodes is represented by Mr. Wagner, and Mr. King, assistant prosecutor, is there on behalf of the state. This hearing is being conducted by Zoom due to safety protocols in place because of COVID. And Mr. Wagner, you and your client are agreeable to waive your presence in court and proceed by Zoom.
We are, sir.
You're in agreement with that, Ms. Rhodes?
Yes, Your Honor.
All right, thank you. All right, now, Ms. Rhodes is charged with aggravated trafficking of methamphetamine and aggravated possession of methamphetamine, both third-degree felonies. This matter is set for trial on the 12th of October. Now, I have been presented with a plea guilty form here, Ms. Rhodes, and it has your name and your case title and your case number. And I'm going to hold that up to you. Do you recognize that form there that I'm holding up to the screen? You can see it. You might need to move a little closer.
Yes, Your Honor.
And on page 3, there are signature lines. There's a sentence about a little less than halfway down that says, I enter this plea voluntarily, and then below that appears the signature. It appears to be Natasha Rhodes, and I'll hold that up as well. And is that your signature? I'm holding up to the camera.
Yes, Your Honor.
And when did you sign this document, Ms. Rhodes?
Today?
And did you sign it there, Mr. Wagner's office?
Yes.
Did he go over it with you before you signed it, explain it to you, and answer any questions you had?
Yes.
And did you understand that when you signed it, that it's an agreement to plead guilty, which means there's not going to be a trial? The next step in your case will be a sentencing hearing.
Yes, Your Honor.
And did you have enough time to fully consider this matter before making this decision?
Yes.
Are you, do you feel you've been rushed or pressured into doing this too quickly?
No.
You're entering into this agreement to plead guilty voluntarily.
Yes.
All right, now the agreement states on page 1 that you're going to plead guilty to count 1, aggravated trafficking methamphetamine under 2925.03A1 of the Ohio Revised Code, and that's a third-degree felony. Further states that you understand that the maximum penalties for that could be 36 months in prison. If a prison term imposed, the minimum would be 9. There could be a fine of up to $10,000. There is a mandatory fine of $5,000. There's a license suspension of 6 months and 5 years. Now, in this case, it's not required that you be sentenced to prison. It's presumed that you should get a prison sentence, but it's not required. Do you understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on community control or probation, parole, or post-release control for a felony from any jurisdiction?
Just, never mind now.
No, not this case, but any other cases.
No.
Okay. Now, under the law, if you are convicted and if you are sentenced to prison, upon completion of your prison term, the law provides that the adult parole authority has the option, if they choose to do so, to put you under post-release control supervision. That means you'll be supervised by a parole officer on the terms that they set. Again, it's optional, not mandatory, so no one knows what they'll do until it comes. And that could be for a period of up to 2 years, as determined by the parole authority, because the judge has no involvement in it. And if that happens, and they determine while you're under supervision that you have failed to comply, they can return you to prison for up to 9 months for any one violation, but there is a half of whatever prison term you serve for all violations that you might commit. But if you commit a new felony while under post-release control supervision, then in addition, whatever sentence the judge in the new case could impose upon you, that judge is also authorized to sentence you, in this case, to an additional period of 1 year, whatever time might be left on the 2 years of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, Your Honor.
Under the law, I'm not required to sentence you to prison. I can impose what's called community control or probation, which means that instead of being sent to prison, you would be put under supervision of a probation officer on a term set by the court for a period of up to 5 years. And if during that period of time the probation department felt that she did not comply, they could file a written notice of that with the court, provide you a copy, and then there would be a hearing at which you would be entitled to be represented by an attorney. And if the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control and then sentence you to between 9 and 36 months in prison and fine you $10,000. Do you understand that?
Yes, Your Honor.
All right, now, the charging count 2 alleges that on or about September 18, 2020, in Huntington County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.0381. So again, that's the charge of aggravated trafficking methamphetamine, a third-degree felony, bearing possible prison term between 9 and 36 months, fine of $10,000, and possible license suspension 6 months to 5 years. Now, you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did.
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, and possible outcomes of the trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Have any threats been made to get you to plead guilty here today?
To me, threaten you.
Oh, no.
Okay.
No.
Now, on page 2, there's 3 sentences that are printed in bold and underlined. Pull those up there. You see those sentences I'm talking about? There toward the bottom page. All right, I'm going to read those to you. Defendant shall either plead guilty to count 1, state will dismiss count 2, state and defense jointly recommend community control treatment. Defendant shall pay $360 in fine money to task force as a condition of the plea. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Under the law, the matter of sentence is up to the judge, not the parties. So even though the state's recommending you get community control and treatment, I'm not required to follow that recommendation. So once I've heard all the information, if I decide that's not the correct sentence, I can impose prison term of between 9 and 36 months, a fine of $10,000, there's also a mandatory fine of $5,000, and a license suspension. You understand that?
Yes, Your Honor.
Likewise, the question of conditions of community control are up to the judge, not the parties. So I will order an assessment for you if I decide that you should be in residential treatment rather than just regular outpatient treatment. That's my call as well, not the parties. You understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state agency or board for any kind of an occupation or profession?
No.
Right, you have rights you must understand under the Constitution of this state and country before I can accept the plea of guilty. The first one is you have a right to counsel, and Mr. Wagner has been appointed representative not for the purpose of simply working the case out, but to provide any defense that could be available to you under the law that you would wish to provide. So besides you do not want to plead guilty, but you want to defend against this case, you will still have an attorney to represent you to defend you during that time, including trying the case if that's what you want. You understand that?
Yes, Your Honor.
The Constitution, Ms. Rhodes, you have a right to a jury trial in this matter in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. Now, after they are selected, the 12 selected, the evidence will be presented, they be instructed on the law, then that jury will decide by unanimous verdict between all 12 and have to agree as to whether or not the state proved you guilty by proving beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, in writing, the waive means to give up your right to have a jury trial, and in that case, you would have what's called a court trial, meaning that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, the judge would apply the law, the judge would decide whether or not the state proved you guilty by proving beyond reasonable doubt. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. So if you have witnesses that you're not certain are going to come in voluntarily at your request, the court issues a court order, that's a subpoena. That forces those people to come to court and be available to testify if they want to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. That is, if there's a jury trial and you don't testify, the judge informs the jury, the judge instructs the jury that because that is your right, they cannot consider that for any purpose. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio of every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence in your defense at trial. Now, you may, but you're not required to. Whether you do or not, the burden remains on the state to prove your guilt by proof beyond reasonable doubt every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
All right, now, originally you entered a plea not guilty. That plea denied the allegations in the indictment, denied you committed any crime, and didn't exercise or invoke all the rights that I just described. If you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits their crime, and that you committed that crime. Now, that plea would waive and give up all the rights that I just described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty would waive and give up the right to have a jury or court trial. It would waive and give up the right to confront witnesses against you, to cross-examine through your attorney. It would waive and give up the right to use the part of the court to compel or force witnesses to be in court to testify for you, just like you state. It would waive and give up your privilege against self-incrimination because you're the one saying you're guilty, so that's what she finds you guilty. It would waive and give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, and it waives and gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence, or under other circumstances you file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. You understand all that?
Yes, Your Honor.
And are you a U.S. citizen, Ms. Rose?
Yes.
And you're entering into this agreement plea guilty voluntarily?
Yes.
All right, now you have any questions about the charge or the possible penalty?
No.
You understand?
Yes.
Any questions about the plea agreement?
No.
You understand?
Yes.
Again, you understand that the recommendation as to sentencing by the parties is not binding on the judge.
Yes.
Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand?
Yes.
Is there anything you'd like to speak to Mr. Wagner about before we go any further?
No.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge in count one as we've just gone over in this written plea agreement?
Yes.
All right, then as to the charge alleges and on or about September 18, 2020 in Highland County, Ohio, you didn't knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, in violation of Section 2925.03A1, charge of aggravated aggravated trafficking of methamphetamine, a third-degree felony, carrying a possible prison term of between 9 and 36 months. The increment provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds that on this day in open court, the defendant was advised of all the constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Rule 11. Plea is accepted and order filed. Defendant is found guilty of count 1. Count 2 is dismissed. Court orders a pre-sentence investigation under the same bond, which will include an assessment for substance use and or mental health treatment. Sentencing hearing will be set for October 21 at 1:30 p.m. All right. gets out of Mr. Wagner's office. Or contact Mr. Bolton, I should say. He must not be listening. As soon as you leave Mr. Wagner's office, call probation. Do you have an appointment set this week with them?
Wednesday.
All right, well, okay, then just go in Wednesday, tell them that you need to meet with Mr. Bolton. You can call ahead of time to let them know that, so that they can set you up with a pre-sentence report in the interview.
Yes, sir.
All right. Anything further from council?
There you are.
All
There you
right,
are.
thank you.
There you go, stay in touch. All right, Wednesday, you're good.
All right,
Thanks for coming in, appreciate it.
Thank you.
All right.
All right, I believe that you may have, is that Brian Mock on the screen under which is Brian is down in the right-hand corner?
I think we're having technical difficulties, Your Honor.
Can you hear me, Mr. Mock? All right, we're showing you as logged in, but, you're not marked as muted, but I don't have your picture, so, you may want to log off, try to log back in. I think that might be the second time he logged in, I know. I've been with a couple different people during the afternoon. I think he might have been in once before. All right, and you have Miss Adams, Mr. Wagner?
I do, Your Honor. I'm not sure where she's at. I spoke to her yesterday, and I know she got a link. I mean, worst case scenario, sir, I'll just treat her like.
You want this on the record? Okay.
Hold on here, let's go on record.
On the
21 CR 117, State of Ohio versus Carol Adams. The Wagner, the defendant's attorney is appearing by Zoom. This matter was set by Zoom for COVID-19 protocol reasons. Assistant Prosecutor King's representing the state. Ms. Adams is not present. So, what can you tell us about her, Mr. Wagner?
Your Honor, I spoke to her yesterday on the phone just to confirm we're going to do it today. I know she did the last Zoom link, and I checked the email that Ms. Oyer sent out, and I saw she was on there. I guess worst case scenario, Your Honor, I'll just appear normally Wednesday, as it was typically scheduled. I know Mr. Parr is in quarantine lockdown at the jail, so he has to be Wednesday as well. So I guess I'll just keep those two regularly scheduled with the court's permission.
All right. Well, go ahead and do that. If necessary, we can do her by Zoom on the afternoon, like at 3 o'clock. I know we have a lot of them set, but I think we're trying to switch everything over to Zoom anyway. So she's not, she was actually set for the 22nd, we'll let go until Wednesday. But tell her if she doesn't show on Wednesday, there's going to be a warrant for her.
I'm going to call her. I got her phone number.
All right. You want to try to get a hold of Mr. Mock?
Yeah, I got a good number with the court's permission. I'll use my phone right now.
Yeah, Mr. Mock, can you hear me?
Yeah. Yes, sir.
Okay, you're breaking up a little bit.
Yeah.
Can you activate your screen there? There should be a button that says start video or share video. If you're on a phone, it'll be down at the bottom of your screen probably. Sounds like a harmonica.
Your Honor, I was on the phone with Mr. Mock's grandmother who's in the residence with him. He's on a computer. It's not a phone, so it's not a dial-up issue.
Okay.
Some kind of issue with his computer.
All right, Mr. Mock, are you there?
Well, he's answering my phone, Your Honor.
Go ahead, talk.
I
Go ahead and
can't
see
talk.
what's going on.
Your Honor, let me put him on speaker and run it through the phone that way.
Have you got him?
I do, sir.
All right. Tell him to log off of the Zoom call. We'll do it that way.
Hey, log off and we'll just do a Zoom call, Brian. All right, I'll put you on speaker, Brian. Yeah, just turn your computer off and go through my phone and do a telecom.
Yeah, I'm getting feedback with both of them. All right, he's gone. All right. Good, put him on speaker now.
I have him here, Your Honor.
All right, can you hear me, Mr. Mock?
Yes, sir.
All right. Case number 21 CR 131, State of Ohio versus Brian Anthony Mock. Mr. Mock is charged with having weapon under disability, receiving stolen property, and forfeiture. His counsel is Jacob Wagner. This matter is set by Zoom. Mr. Wagner is appearing from his office by Zoom. Mr. King, assistant prosecutor, is appearing from his office. Mr. Mock did try to log in, and we were having trouble hearing him and couldn't see him. So he is now on the phone with Mr. Wagner. Now, this is a first pretrial, and the defendant's final pretrial is set for October 6th, and a trial date of the 25th of October. I see the state's provided discovery, and have you done yours yet, Mr. Wagner?
I have not, Your Honor.
All right, yours will be due by final pretrial. Do you anticipate any pretrial motions?
If anything, a Fourth Amendment issue, Your Honor, but I'll have it filed by the 6th.
All right, by final pretrial then, all right. And has there been a written plea offer provided?
It has, it's been verbally relayed. Brian was in, but he bonded out, so I don't recall if I got him a hard copy of his discovery yet. If not, I need to get him one.
All right. All right, then, are there any other matters then to come before the court?
Not right now, sir.
No, Your Honor.
All right, well, the court's intent, I asked President Barr to send out a notice, I don't know if she did yet or not, to the bar, that we're gonna switch everything over to Zoom if we can. So, might talk to Mr. Mock, if he still has the same access, maybe it'd be better for him to come to your office or try another computer or phone so we can get him better for the final pretrial.
We have a good number, so I can take care of that, sir.
All right, anything further then?
No, Your Honor.
Okay. Mr. King, if you would stay on, I got a couple of clerical matters to talk to you about.
Okay.
On the intervention.
Off the record.
Yeah,
Off the record,
On
okay.
the intervention and lieu stuff, you need to add to that, right now the form has not been updated since the law changed to allow for mental health